Good evening and welcome everyone. My name is Alison Duxbury and I am the Deputy Dean of Melbourne Law School, and it is my pleasure to welcome you to this evening's event launching the book Legal History Matters from Magna Carta to the Clinton Impeachment, edited by my colleagues Associate Professor Amanda Whiting and Professor Anne O'Connell, and here is a copy of the book that we are launching this evening. I want to begin by acknowledging the peoples of the Kulin Nation as the traditional custodians of the land on which I am working on today, and I wish to pay my respects to their elders, past, present, and emerging. I also acknowledge the traditional custodians of the land on which you are all meeting today, whether that is in Melbourne, Victoria, Australia, or across the world. I also extend this acknowledgement to all Aboriginal and Torres Strait Islander people joining us today. So as I said, the purpose of this evening's proceedings is to launch a book that has been edited by two of my colleagues, Associate Professor Amanda Whiting and Professor Anne O'Connell. And to launch this book, we have with us this evening our guest speaker, the Honourable Justice Steward, who will be officially launching the book. Following Justice Steward's comments, we will hear from Associate Professor Amanda Whiting and Professor Anne O'Connell, who will both say a few words. Before I introduce our guest speakers this evening, I'd like to just note a couple of housekeeping matters. Firstly, the chat function has been disabled. And secondly, tonight's proceedings are being recorded and they will be available on our website soon. Now, before I turn to Justice Steward, I'd like to give some background to the book Legal History Matters, as the story behind this publication is in itself incredibly interesting and also an excellent example of staff-student collaboration at Melbourne Law School. From 2014 to 2019, Associate Professor Amanda Whiting led a legal research stream for JD, Juris Doctor students entitled Treason, Sedition, Heresy and Dissent, Political Trials in History. And in 2015, she led a stream to mark the 800th anniversary of the Magna Carta, titled Magna Carta, History, Myth and Law. Now, legal research in the JD program is taught in classes of up to 15 students towards the end of their Juris Doctor degree, and students are usually in final year. Students are led by a researcher in a specific area before identifying their own topic and continuing with expert supervision to write and research a paper on that topic. Amanda was so delighted with the papers that she determined to work with the student authors to publish them. Some papers were published in journals shortly after the students completed their degree. Joined by Professor Anne O'Connell, who generously funded the project, the two colleagues decided to publish the collection of student papers and to dedicate it to two legal historians and former colleagues, Dr. Ruth Campbell and Mrs. Betty Hayes. As an aside, I should say I remember being a student of Dr. Ruth Campbell in legal history, which was taught as part of a compulsory subject in the first year of my LLB degree. Classes were not for the faint-hearted law student because they began at 9 a.m. on Friday mornings every week throughout the academic year. Now, many of the chapters in the book won the Campbell-Hayes Prize for Legal History. And so I celebrate this publication as a partnership between colleagues, as well as a partnership between students and teachers. And it is this partnership that has delivered papers on a diverse and fascinating array of areas with intriguing titles and subtitles, including Anne Boleyn's trial placed in context, the aftermath of the Eureka Stockade, putting capitalism on trial, and politics, partnership, and the president on trial. So now it is my privilege to introduce tonight's guest speaker, the Honourable Justice Steward of the High Court of Australia. His Honour was appointed to the High Court in December 2020. At the time of his appointment, he was a Justice of the Federal Court of Australia, to which he'd been appointed in February 2018. Justice Steward was also a Deputy President of the Administrative Appeals Tribunal in June 2018. He holds honours and master's degree in law from the University of Melbourne. Justice Steward was admitted to practice as a solicitor in 1991, and he was called to the bar in 1999, where he practiced in revenue law. He was appointed a Queen's Counsel in 2009. Now, I believe also that prior to being called to the bar, Justice Steward also worked at Mallison Stephen Jakes, now King and Wood Mallisons. And I just mention this because it is particularly pertinent in this context, because Dr. Campbell wrote a history of Mallisons formerly. Justice Steward, we are honoured to have you with us for this special event, and I will now hand over to you for the official launch. Thank you very much.
Thank you, Professor Duxbury, for those very kind words. It's my very great privilege and pleasure to be asked to launch this book. The study of history generally is a vital necessity. It is the database which permits us to understand our fellow human beings and to make predictions about the course of future events. It is the bedrock of wisdom. In my case, I started with art history, reading about artists and artistic theory from about the age of 11. It was Kenneth Clark, the great art historian, who observed that despite recent triumphs in science, people have not changed much in the last 2,000 years. He said, and I quote, "In consequence, we must still try to learn from history. History is ourselves." The history of the law is equally a vital necessity for any lawyer. This is not limited to the common law. Legislative history is very often a critical attribute to correct statutory construction. Any student of the decisions of the High Court will see that the court again and again looks to the applicable legal history as a sure and necessary guide for the determination of correct principle. And the very doctrine of stare decisis ties the law to its history and ensures that it develops not in leaps and bounds, but incrementally with each decided case. Legal history is especially important in the field of constitutional law. No case concerning our Constitution is ever decided without the benefit of our constitutional and governmental history. Take, for example, the recent decision of Palmer against Western Australia, which concerns Section 92 of the Constitution, and its requirement that intercourse amongst the states shall be absolutely free. What did those words mean? The reasons of the court are replete with historical references, including to the official record of the debates of the Australasian conventions in the late 19th century. The court has often endorsed the observation of Sir Robert Menzies that constitutional law in a federal system is a unique mixture of history, statutory interpretation, and some political philosophy. At the bar, no case could be prepared without a full knowledge of the history of an applicable principle or legislative provision. This was often the job for junior counsel. Sometimes the research was interesting, sometimes it was not. In one of my first cases at the bar, I had to examine in detail the history of the taxation of superannuation funds since 1916. That history was extensive, but it could not, on any view, be described as exciting. It is a simple fact that as cases move up the appellate chain, the battle to find support for a proposition in legal history becomes all the more urgent. That is because in order to achieve principled outcomes at the highest levels, one must understand the origins of our legal system. Incidentally, older textbooks are treasured by busy advocates. I retain, for example, my father's first edition of Halsbury's. It was often used, especially when I was in a jam. In the words of Justice Leeming of the New South Wales Court of Appeal, who himself recently expounded on the importance and uses of legal history in advocacy, His Honour said, "An appreciation of historical context permits one to distinguish what continues to matter in a court's reasons from what has long been superseded." When I was at the Melbourne Law School in the 1980s, legal history was a compulsory subject for first-year students. In my case, it was taught by Professor Robin Sharwood, and the lectures were held from memory on a Friday morning. Professor Sharwood was an immensely impressive legal scholar and a true gentleman. Himself an alumni of this law school, he won the Supreme Court Prize in 1953. He was destined for the bar and great success and eventual judicial appointment, but then the man in the painting behind me intervened decisively. Sir Zelman persuaded Professor Sharwood to become a legal academic. In the early 1950s, that was an uncommon career path. I greatly looked forward to those Friday lectures at a time when I knew so little law. The study of its history enabled me to draw the threads of legal principle together. We studied, amongst other things, the origin of common law writs, the rise of equity, the fusion of law and equity, which incidentally the people of New South Wales steadfastly resisted until 1972, the development of the doctrine of the freedom of contract, the rise of parliamentary sovereignty, and the history of Australia's governmental institutions. For my part, it is a very great shame that the study of legal history has ceased to be compulsory. The benefits of the examination of legal history can be seen in the book that I launched today. I applaud the efforts of the now former student contributors from the Melbourne Law School and the law school itself. One such former student, Miss Ali Harrison Ishlov, now solicitor at Arnold Block Liebler, has described to me the very great pleasure she experienced in long visits to several libraries, which led to her uncovering the trial of the suffragettes Emmeline and Christabel Pankhurst, as well as the woman known as the General, namely Flora Drummond, at the Bow Street Court in London in 1908, where they had been charged for distributing at handbills at Trafalgar Square, which bore the following proclamation: "Men and women help the suffragettes to rush the House of Commons." Miss Harrison Ishlov's research required her to examine a range of historical sources, including newspaper articles and some very well preserved turn-of-the-century pamphlets about the suffragette movement, which had been retained in the Bayeux Library. Miss Harrison Ishlov in particular praised her supervision by Associate Professor Amanda Whiting. She wrote to me and said, "I was grateful of her expertise and guidance. Amanda's passion for legal history as a discipline made a significant impression on me and inspired me to undertake a paper on the history of English civil and criminal law during my subsequent master's studies at the University of Cambridge." Two aspects of the Commons trial are noteworthy. The first is the extraordinary meeting between the Commissioner of Police, Sir Edward Henry, and the magistrate who was to preside at the trial. That meeting took place before the suffragettes had been arrested, and at it, the Commissioner sought advice from the magistrate as to whether the word rush could be construed as a reference to a direct incitement to violence. Such was the state of Britain's constitutional arrangements in 1908. The second is that the magistrate permitted, in a great moment of procedural fairness, the suffragettes to subpoena or summons to the court to give evidence both the then Chancellor of the Exchequer, David Lloyd George, and the Home Secretary, Herbert Gladstone, who was the son of the former Prime Minister, William Gladstone. Both were cross-examined. This led to many dramatic and sometimes amusing moments, one of which is set out by Miss Harrison Ishlov, and which I must repeat. Mr. Gladstone was cross-examined by Christabel Pankhurst about his supposed encouragement of popular support for the suffragette campaign. The following exchange took place. Ms. Pankhurst: "Did you say this? There comes a time when political dynamics are far more important than political arguments. You said that?" Mr. Gladstone, yes. Ms. Pankhurst, and that men had learned from this lesson? Mr. Gladstone, yes. Ms. Pankhurst, and that they know a necessity for demonstrating that force majeure which actuated and arms a government for effective work? Yes, said Mr. Gladstone. I think it a most excellent speech. Ms. Pankhurst, I agree with you. Did you say that that was the task before the supporters of this great movement? Mr. Gladstone, yes. Ms. Pankhurst, did you speak of people assembling in tens of thousands in the 30s, 60s, and 80s? And do you know that we had done it on Woodhouse Moor and Hyde Park? Yes, said Mr. Gladstone. Ms. Pankhurst, then why don't you just give us the vote then? There followed much laughter, touche, as they say. Incidentally, all of the accused in that case were Mancunians, that is, they were born in Manchester. Christabel Pankhurst had an honours degree in law and was, despite her criminal convictions, eventually made a dame in 1936. She had a sister called Adela who came to live in Australia. She must have also been a remarkable woman, for she was a founding member of the Communist Party of Australia, but then later on joined the far-right movement, Australia First. The essays in the book expose 9 very different areas of legal history. In each case, the reader is transported into the past. We could see that in the exchange between Ms. Pankhurst and Mr. Gladstone. The authors illustrate how tracing, analysing and understanding history has oftentimes stimulated attitudinal and behavioural shifts, or has served as a reminder of the errors of the past. Fortified with the knowledge and appreciation of how the doctrines of law that exist today have been shaped, worked, sometimes beaten and polished, the lawyers of tomorrow will be better equipped to serve, in my view, our ancient profession. This book is dedicated to Dr. Ruth Campbell and Ms. Betty Hayes, both of whom were pioneers of legal history teaching and authorship at the Melbourne Law School in the 60s and 70s. I regret that I was not taught by either of these distinguished women, although I did have the great fortune of being taught French and American history by another pioneering woman, Dr. Alison Patrick. The legacy of Dr. Campbell and Mrs. Hayes is rightly upheld by the book, which honours those learned women and their expertise. They would no doubt be very proud of its contributors. Finally, I would like to congratulate and thank Professor Anne O'Connell and Associate Professor Amanda Whiting for editing the book. I endorse all of their efforts to promote the study of legal history. I now officially launch Legal History Matters from Magna Carta to the Clinton impeachment. Thank you.
It now falls to me, as one of the 2 editors of Legal History Matters, to deliver some thank yous. The first expression of thanks, of course, is to you, Justice Steward, for so graciously agreeing to launch our book and for your kind and immensely informative remarks just now. Your support for the discipline of legal history and this student-led contribution to it is so very greatly appreciated. And by the way, I remember Alison Patrick with great fondness too, she taught me. During preparations for this event, we've received emails from some of the authors who have told us they are really thrilled that a Justice of the High Court of Australia might read their words. All of us who've been involved in this book and this launch event are acutely aware that a judge's time is precious and that judicial responsibilities cannot lightly be put aside. And so we are immensely grateful to you for making the time to be with us this evening to celebrate the achievements of these marvellously talented former students. We're also immensely grateful for your support because, as Anne and I set out in dismal detail in the introduction to Legal History Matters, the teaching of legal history apparently does not matter any longer in Australian law schools. It is nearly extinct. The reasons for this are poorly understood, certainly under-researched, and it's something that's on my to-do list, but they are generally taken to include this conflicting mixture of the commodification of legal education and its marketing as practical training stripped of any intellectual content that cannot seamlessly and swiftly be applied to commercial ends. The tyranny of audit culture and student experience surveys, fee-paying students' hesitancy, despite their interests and their passions, to do a subject they fear the job market may consider frivolous, and the legal history's unfortunate reputation as tedious and unmemorable, to quote the ever forthright Justice Michael Kirby. If reversing the subject's decline requires negating each of those factors, the task appears insurmountable. And yet, legal history is flourishing as a field of academic research, generating monographs, edited collections, specialist journals, conferences, graduate programs, and scholarly blogs of very high quality and great sophistication. Academic researchers are producing vibrant and exciting works of legal history, but the subject is now rarely offered to law students. Meanwhile, the public, it seems, cannot get enough of history as entertainment, whether it's detective novels set in late Tudor England, TV miniseries set in Weimar Germany, cinematic reimaginings of Winston Churchill's preparations for Dunkirk, or a biopic of RBG. Popular appetite for all things historical is apparently insatiable. It's confounding, this disconnect between how the overwhelming majority of Australian law schools prepare young adults to be lawyers these days, and the intellectual rewards that at least some young adults apparently get from exposure to history outside of their formal legal studies. If the teaching and learning of legal history is to be kept on life support, let alone incrementally revived, the cunning plan behind our book, then it needs all the endorsement that it can get. And so we thank you, Justice Steward, for yours. Before I turn in my own way to acknowledge the talents and hard work of the 9 marvellous contributors to Legal History Matters, I must also make a deeply felt personal statement of thanks to my co-editor, Professor Anne O'Connell. From 2014, when I commenced teaching the legal history seminar in the capstone JD Legal Research subject, I had hoped and imagined, but never really concretely planned, how to publish a volume of some of the best student papers as a way to showcase our students' talents and perhaps foster the next generation of writers and readers of legal history. I'd helped some students to publish in journals, but the volume was something I'd always wanted to do, but I didn't quite know how to go about it. My inspiration was also a volume of student essays called Encounters with Singapore Legal History, edited by my dear friend and long-distance colleague, Professor Kevin Tan of the National University of Singapore. But typically for me, I procrastinated. A chance meeting with Anne beside the lifts on the 7th floor of the law school made everything happen. Anne's ambition, as you've been told, was through a proposed publication of excellent student essays to honour the memory and achievements of her esteemed friends, legal history teachers Dr. Ruth Campbell and Mrs. Betty Hayes, in whose names Anne had established and endowed the law school's Legal History Prize. And so the project that became Legal History Matters, the book we're launching today, or that Justice Steward has just launched, was conceived through Anne's initiative, energy, and I must say, generosity, because she personally funded the employment of our assiduous editorial assistant, David O'Loughlin, and she's picked up the tab for a number of other things along the way too. This evening's event may well be Anne's last such duty, because she's shortly to retire from her position at Melbourne Law School. I envy her her time in the garden, but when I think of her leaving, I remember also all the many small acts of friendship and feminist solidarity that she extended to me from almost the first day that I commenced here. Her desire to promote our students' achievements through publication as a tribute to Dr. Campbell and Mrs. Hayes is a quintessential expression of Anne's values and generosity as a colleague, a teacher, and a scholar. It makes me quite deeply and overwhelmingly sad to think of her leaving, and yet reassured to know that she will continue her professional association with us as in an honorary capacity, and I look forward to that and to my continuing association with her in that way. Now to the contributing authors. I won't describe or summarize their skillful and creative essays because there's no time to do so really. And it would be invidious to select only a few. However, we want you to buy the book. So I have a selfish reason not to do so as well. And certainly recommend it to your libraries, and I call upon you to read the book closely and pay attention to these essays with the attention they deserve. But I will name the authors. Matt Zakaris, who's written about the use of Magna Carta in the 16th century. Lizette Stevens, who wrote about Anne Boleyn's trial. Phoebe Williams, who wrote about the 19th century view of Magna Carta. Sam O'Connor, who wrote about the political and historical legacy of the Cold War Hiss prosecution. Xavier Niccolo, writing about sedition and treason in the aftermath of the Eureka Stockade. And Ali Hitchloff, as you've already heard, Ali Harrison Hitchloff, who wrote about the prosecution of the women's suffrage campaigners in 1908. Jack Townsend, who wrote about the failed prosecution of criminally negligent and yet acquitted factory owners in an infamous fire in early 20th century New York. Simon Pickering, who wrote about the sedition trial of Brian Cooper in the mid-20th century. And Catherine Kilroy, who wrote about the impeachment and acquittal of President Bill Clinton in 1998, with some late-breaking footnotes to accommodate Donald Trump's impeachment. And stopping myself there. And I can also acknowledge that these authors' commitment to seeing the project through to publication is a testament to their intellectual engagement with legal history and the subject matter of their individual essays. And it's also, frankly, rather heroic because they had to find hours to revise, check, and update sources and proofread after long days at the demanding coalface of early career legal practice, or in the case of Matt, the responsibilities and preoccupations of a PhD program at the University of Cambridge. Anne and I hope and expect that when you, the audience, read these accomplished pieces of research, you will see how law students learn the value of legal history and learn how to do it by being given the opportunity in a law school with a good library to apply their lively and critical intelligence to a puzzle about the past and to wonder about the distinctions between then and now. The act of explaining the past to the present in terms readers in the present can understand is what history does. And these student authors, now young professionals, have done this superbly. Matt, Lizette, Phoebe, Sam, Xavier, Ali, Jack, Simon, and Catherine. Your partners, your parents, siblings, colleagues, and friends should be very proud of what you have done. We certainly are. So now moving on, I must also give thanks to the Honourable Julie Dodd-Streeton QC, who enthusiastically agreed to write some prefatory remarks for Legal History Matters, diligently read each and every page of the manuscript, and then penned such an engaged and engaging foreword. She has a lifelong interest in historical studies and a very impressive understanding of late Tudor history, arising from an earlier pre-law career as a young academic in history. In 2017, as judge in residence at the Melbourne Law School, she shared some of her historical knowledge and passion when she attended the work-in-progress oral presentations of students' legal history projects, generously offering astute words of critique and encouraging advice for each and every student presenter. When she received the Legal History Matters manuscript last year in the very depths of the pandemic, she was very pleased to see that two of the students from that 2017 seminar, Xavier and Jack, are contributors to this volume. Owing to a prior engagement, Julie is not able to be with us this evening, but is looking forward to participating retrospectively through viewing the video recording of this event. We gratefully also acknowledge the assistance and wise advice of Dr. John Waugh, whose book, First Principles, the Melbourne Law School 1857 to 2007, will, I'm sure, be well known to many of you. When Anne and I were working on the overview of legal history teaching and learning in Australia for our introduction, we turned to John for his expert understanding of the Melbourne Law School and of the Melbourne Law School's history and for the university's archival holdings. Particularly, he helped us to unravel the mysteries of 19th and 20th century university calendars and handbooks. And we thank you, John, for that. And finally, warm thanks are due to Dr. Tanya Joseph. We thank her for being such a staunch, enthusiastic and supportive fellow legal history colleague and for applying her expert eye to the penultimate draft of our introduction. Last year, I'm pleased to say, Tanya led a legal research seminar on the High Court of Australia in the 20th century. So I'm hopeful that we will see some more outstanding legal history papers, student legal history papers in the publication pipeline soon. There are, of course, many more people to recognise and thank for their assistance and contribution in the long time it took to transform the idea for this volume into print, and I realised only this morning into digital publication too. Anne, who will speak next, will say some more thank yous on behalf of both of us and some other words of her own. But please know that if through time constraint I have not been able to mention you by name, we are nevertheless aware of and grateful for all that you have done to make Legal History Matters a reality. So I will now hand over to Anne.
Thanks very much, Amanda. I would just like to join with Amanda in thanking you, Justice Steward. I do understand how busy you are and would like to congratulate you on your recent appointment to the High Court. I think we were extremely lucky that you would agree to launch our book. You've been a long-standing friend of the law school, having taught in the Tax Masters program for a considerable period of time. But I suspect that one of the things that might have got us over the line is that you are such a legal history buff. And I think the project had appealed to you from the time when I first mentioned it to you. I'd also like to join with my wonderful colleague, Amanda, in congratulating the students. It's lovely to have your first, or in some cases, your second publication now. You have demonstrated excellent research skills and you've woven those skills together to make really interesting stories. I think this book is one that appeals to both lawyers and non-lawyers just because of the very interesting stories that are contained in them. I'd also like to acknowledge David O'Loughlin, who we were able to secure as our research assistant. I think he's a research assistant par excellence. He was very diligent and quick in dealing with the essays, in making sure that they were all in the same style and that they conformed to the Australian Guide to Legal Citation. And I must say that his diligent work made our task a lot easier when we actually had to review the manuscript. I wanted also to say something about Amanda, and Justice Steward has mentioned that she is really appreciated by her students. When I first read the essays that formed the book, I was blown away by what I could see as the skill that she had imparted to the students and the enthusiasm for legal history. Amanda is on a mission to see legal history reintroduced into law schools, and we think that this book makes a really good case for that. And if not, it will be inspiring, I think, to students in the future as to how they can utilise their research skills in this way. I want to also thank the publisher, Melbourne University Publishing, and the actual publisher, Dr. Nathan Hollier. He took a punt on publishing a book that contains student work. I think, again, we were really lucky in that Dr. Hollier had a link to the law school. His father-in-law is Robert Evans, also a former colleague and somebody who worked with Dr. Ruth Campbell and Betty Hayes, and I think that might have helped. In addition, Dr. Hollier is also a history buff. So we thank Melbourne University Publishing in that regard. I'd like to thank Professor Alison Duxbury, our Deputy Dean, who has stepped in at the last minute today because our Dean, Professor Nicholson, is unwell. So thank you so much, Alison. Your comments were really insightful, and I'm so pleased that you were taught by Ruth, because that does provide another valuable link. I'd also like to thank Dorothy No, who has organised this webinar and has done so seamlessly. She's really managed to get invitations out and everybody organised in a way that Amanda and I are so grateful for. Look, finally, I'd just like to say something about my two friends, Ruth and Betty. I taught with them in the 80s, but I think they had started in the law school perhaps in the late 60s, and certainly were working in the 1970s. We know from John Waugh's book that they were only perhaps the second and third women to join the law faculty, and that the first woman lecturer, her appointment had been opposed by some of the other professors who wondered how they would get by because there weren't any female toilets in the law school. So we had Ruth and Betty coming in at this so quite unique time, I guess. They were both essentially single parents, and so they had young families and demanding jobs at a time when that wasn't really common, and they both did brilliantly. Ruth lectured in the first truly Australian legal history course. I think Amanda and I found that legal history had been part of the curriculum on and off since the law school started, but Australian legal history was not yet commonplace. Ruth also wrote a history of the law school from 1857 to 1973, and interestingly got some of her students to write histories of some of the former deans, and the whole book makes excellent reading. She also wrote a history of Mallesons, which has already been mentioned, for which she was awarded a PhD when she had turned 60. So her life was dedicated to history and to legal history, and her friend Betty Hayes was a tutor in legal history. And I remember when I arrived, they kept talking about how wonderful it had been to have Zelman Cowan as their dean and how welcoming he had been to them. I still remember when you would see Ruth in the corridor, and when she would say goodbye to you, she would always say happy days. And it's something that I'll always remember about her. It was such a nice thing to say before we heard of lots of other things like have a nice day. I'll also just mention that she was greatly admired by her students. The author Kerry Greenwood described her as the most excellent of historians and credited Ruth with having introduced her to the value of primary research. So that's really all I wanted to say. I might ask Dorothy if she'll put up the screen, because we would encourage you to buy the book, those of you who haven't already been given a copy of it. And I'll just mention that the link there to the Melbourne University Publishing website is also available in the chat function. And finally, I might just tell you that Amanda and I have decided that any royalties from the book will go to the law school to assist in funding the Campbell Hayes Legal History Prize into the future. So I think it just remains to say thank you all for attending. Thank you again, Justice Steward, and thank you to my wonderful colleague, Amanda Whiting.